2nd, 2016. It is 6 p.m. Call to order. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Roll call, please.
Gary Cunningham.
Here.
Steve Griffiths.
Here.
Riley Hoagland. Doug Bryson is absent and excused. Deanna Hinton is absent and excused. Bruce Robinson.
Here.
Thanks.
Are there any changes or revisions to the agenda?
There are none.
Can we have a motion to approve the meeting minutes for July 19th, 2016?
I motion we approve the meeting minutes for July 19th, 2016.
Second.
All in favor?
Aye.
Opposed? Carried. All right, public comments on non-agenda items or matters not involving a public hearing. Any interest in that? No, thank you. No final orders, resolutions, written communications. Okay. Public hearings, deliberations. It's now 6:01 p.m. Public hearing for file MISC 2016-02 is now open. This public hearing concerns a request for restoration of a substantially damaged lawful non-conforming structure or use, as provided in Lincoln City Municipal Code Section 1764-010E. The project site is located at 6019 Southwest Highway 101, map 071134DA, tax lot 1000, and is in the Recreation Commercial RC zone. The applicant property owner is D. Allen Black. The property is the former Crab Pot Fish Market, a legal non-conforming structure in the RC zone. The request is to rebuild the fish market on the same footprint as the store that burned in 2014. The Commission must take a few moments to cover some preliminary matters and required statements. Does any member of the Commission wish to declare an ex parte contact, conflict of interest, or bias in this matter? No. Seeing none. Does any member of the audience wish to challenge the qualifications of a commissioner to participate in this matter? None. Does any member of the audience wish to challenge the jurisdiction of the commission to consider this matter? None. Following statements are required to be made at the commencement of the hearing pursuant to the City Code and ORS 197.763.5. Staff will now read a list of the applicable substantive criteria for this decision.
The Planning Commission's decision must be in conformance with Chapter 1764, Nonconforming Situations, Section 1764.10, General Provisions, E, Restoration of a substantially damaged lawful nonconforming structure or use.
Thank you. All testimony, arguments, and evidence must be directed toward the applicable substantive criteria previously listed or such other criteria in the plan or land use regulations which the person believes applies to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal to LUBA, the Land Use Board of Appeals, on that issue. Failure of the applicant to raise constitutional or other issues related to proposed conditions of approval with sufficient specificity to allow the decision maker to respond to the issue precludes any action for damages in circuit court. Prior to the end of this hearing, any person who participated may request a continuance to provide additional testimony, argument, or evidence, or request that the record be left open to submit additional written testimony, argument, or evidence. Before the staff presents a report, I would like to summarize the adopted public hearing procedures. Generally, the order of proceedings will be as follows: preliminary matters and required statements, the staff report, questions of staff, applicant's presentation, those in favor of the application, those opposed, rebuttal by the applicant, requests of continuances or to leave the record open, close of the hearing, close of the record, request to submit written argument, deliberations, and decision. The city has established some time limits. The applicant will have 15 minutes and may reserve up to 5 minutes of that time for rebuttal. After the applicant testifies, any person may speak for up to 3 minutes. If the Planning Commission has questions, your time responding to any questions will not be counted in your time limit. If you wish to speak, please write your name and mailing address clearly on the sign-up list at the entrance. Please speak directly into the microphone. Begin by stating your name. If you have, excuse me, if you also have written testimony to submit into the record, please provide a copy to the recorder. Please present the staff report.
Thank you. Okay. Well, I always come with a paper copy. You won't be able to see the pictures, but you have them. There we go. Okay. This is the location of the former crab pot. It, as you mentioned, burned down a couple years ago, and the owner is in front of you this evening to see if you will grant him permission to rebuild to the same footprint. All that is remaining of the building is a part of the foundation. The foundation is closer to the lot lines than would be allowed under the current RC zoning. So here are a couple pictures from Google Earth showing the crab pot. The Commission has the authority to review the application to restore a lawful nonconforming mixed-use or commercial structure. I'm sort of paraphrasing this from the code. And you shall conduct a public hearing. So that is what we're doing this evening. Your decision must include findings of all of the following. The damage was not caused intentionally by the property owner. We have no reason to believe that Mr. Black caused this intentionally. It destroyed both his business and his home. 2, the restoration does not increase nonconformity or add new nonconformity. Restored structures must conform to other requirements of the code. The RC requirements are that the front yard should be 5 feet. The required side and rear yards also should be 5 feet, except that the street yard shall also be a minimum of 5 feet. The rear and side yards would increase by a ½ foot for each foot that the building is over 15 feet. So the southeast corner of this building, okay, so here's the crab pot right here. And this is the RC zone. Now, I have overlaid on this, it looks like it's been distorted a little bit, but I have overlaid the plan that Mr. Black has provided for his new building that he would like to build, the new crab pot. And I've overlaid it on our aerial photo and lot map. The green lines here are fairly faint, but they're showing you the lot lines. There's a notch in this corner. And then the black lines are the plan lines. So here is the new footprint that he would like to use for his building. And it basically approximates the old one, although the old one extended further back into the north. The lot lines, or the plans for the new building, you can see approach the lot line in this corner. They seem to be at the lot line, also in the southeast corner, and also this line on this side. So they are very close, but they do not extend over the lot line. The designer gives 19.5 feet as the height of the proposed building. The previous building, which is in the setback, which is in the attached street view image that I just showed, appears to have been two-story and had no minimal setback at all, or just no or minimal setback. So the new structure at 19.5 that also approaches the lot lines is really not increasing the degree of nonconformity. Here are the elevations of the building. This is the fish and chips, fresh seafood. This is the front of the building that would face the highway. I have to catch up here a minute. Buildings in the recreation commercial zone must meet the commercial design standards in 1774. This property is also in the Cutler City Pearl, so that's a little bit higher standard. The site, and we'll have a site plan review later on when he brings in his plans that will go through all the criteria for commercial design standards. But right now, the concern is whether the building in this position would meet the intent of the commercial design standards. They require that typically that buildings be located close to the sidewalk, close to the right-of-way for more of a street presence, and that they extend from one side lot line to another to the extent possible to fill in the space. So what the commercial design standards are trying to avoid are little buildings set way back behind a parking lot, or that don't have a significant contribution to the streetscape. So in this case, he has his building, as you saw in the previous slide, right up to the lot line, and it extends for more than 50% of the frontage along the front. It does provide a little bit of space in between the lot line and the front of the building for his customers to stand and purchase his fish. Okay, so on the south side, another thing that the commercial design standards requires is a certain amount of transparency. In pearls, it's 60% of the front street-facing facade has to be windows or doors, something glass, something transparent. So this is the south elevation, so it does not require that of another elevation. He would not be allowed to put windows and doors in this if it was in this side of the building if it was located that close to the lot line. So that works out rather well. Okay, restoration, the third criteria is restoration is according to plans approved by the fire marshal, the building inspector, the floodplain manager, and if required in conformance with a geotechnical report. The fire marshal looked at the plans and sent me an email, said that the access to fire hydrants is okay, fire flow in that area, meaning the amount of water you can get through the main and the laterals is okay. Access is okay. That means that the fire truck is able to reach the building with their 150-foot hoses. And he also said that then he'd be okay with the rebuilding if the fire-rated south wall has no openings. The building inspector, again, said the south wall must be fire-rated and have no openings if it's going to be that close to the lot line. The floodplain manager is me, and the building is not in the floodplain. It is very close to the floodplain. Here's the corner of the building, and here's the floodplain. It's about a little over a half a foot. But as long as the building does not touch the floodplain, it does not have to meet the special flood hazard requirements. The sixth criteria is that it would not interfere with the intent or purpose of the zone. Oops. And so I would like to share with you that the property is in, again, the commercial recreation Comprehensive Plan Development District and the RC Residential or Recreation Commercial Zone. The purpose of this comprehensive plan district is to provide for those commercial uses having a strong tourist orientation, such as motels, restaurants, recreational outlets, gift and souvenir shops. The purpose of the district, the zoning district, is to encourage development of certain areas having a quality resort character. And it's to provide for those commercial uses having definite relationship to the community's resort and recreation industry. Allowed herein are uses that provide food, lodging, recreational activities, and services that have a resort rather than a carnival character. The fish market and takeaway restaurant that he intends to create fits well within this proposal purpose of the comprehensive plan and the RC district. So, my recommendation to you is that you hold your public hearing. You decide whether the proposed reconstruction meets the criteria that would allow the owner, Alan Black, to rebuild the crab pot to its former footprint and height. And I suggest a condition on the approval if you do decide to approve, given that it is so close to the lot lines and to the flood plain. I would suggest that we require that the owner provide a survey at the time of footing inspection, just to make sure that we're not crossing any lines. So, because if we do find that it's in the floodplain after construction, then we have a problem with FEMA, and we don't like to do that because that could cause us to lose our standing in the National Flood Insurance Program. And of course, we don't want to allow construction on someone else's property. So that is all I have for you. Do you have any questions?
Questions?
I have one. Are there other buildings in that neighborhood that come right up to the property line, are built right to the property line?
Let's see if we can see on the aerial photo. To the north is a vacant lot, essentially. And it's sort of a triangular lot that is between here and the street that comes in on an angle off the highway. To the south, those are, what you see in the aerial photo are two temporaries that were illegally placed there a number of years ago, I guess when the photo was taken, and have since been removed. So beyond that, I can't really tell you unless you can see from here. Here's the Freed Gallery, and that's further south on the next property, and it looks like that one end of the building comes pretty close to the property line.
So customers would be pulling up in front of the crab pot to make their purchases?
Well, actually, that's kind of what used to happen. In this plan, they're showing that customers would come off through a driveway. Here's the building right here, and then they would drive in off the highway into the parking lot, and there would be places to park back here. Also, you know, this is a vacant lot, and I guess customers of the crab pot used to park there unofficially. I guess an interesting wrinkle here, since you raised the question, is that there has been discussion about changing the alignment of Southwest Jetty so that instead of coming in off the highway at an angle, it would come directly in right here along the north side of the crab pot. If that's the case, and that idea has surfaced, and then it's kind of died for lack of interest. Apparently, you know, the adjoining property owners are talking about it again. So if that happens, and Mr. Black has not yet submitted, or, you know, has not gone through site plan review, he may want to, you know, revise his plans to actually come in from the north side, and then have more room in the front for picnic tables or, you know, things to serve his customers. So I hesitated to bring that up because it does kind of complicate his planning, but I do not think it really is pertinent to your decision.
What is that structure to the south?
These. Right
Yeah,
here.
that.
Yes, I said those were temporaries that were illegally placed there.
Okay, so they're gone.
They are gone.
They're gone. Could I get another look at that aerial view that showed the crab pot and the other structure further south?
Oh, sure, the Freed Gallery. Mhm.
Yeah, that one.
There. Mhm.
What, and who owns the property just to the south? Well, I don't know if that's pertinent or not.
Well, James
What in-
Drayton, it's public information, James Drayton owns that property. There we go. Mhm. And
So the
Nikki
zero
owns
lot, the
this
zero
also.
lot line might be considered an encroachment on his space. I mean,
Well,
zero
as
lot
long
line,
as it's non-conforming because it doesn't meet the required setback in the zone. It's not encroaching over the line and onto the neighbor's property.
That's where that cement wall is on that south side.
Cement wall is right, it's right along, and part of that remains after the fire, and the,
Do you know if that's intended to be reused?
I don't, and you could ask the applicant. The foundation that remains is in bad shape. It has some problems. The water utility is, has some issues and may need to be replaced. So,
But there have been no written comments from property owners in the area about his request, correct?
no, there haven't. Kate, did you send notice to 250 feet? Mhm.
Any other questions, gentlemen? Thank you.
You're welcome.
May we have the applicant's presentation, please?
I was at this, and bear with me. And, I think all the essentials are covered, other than the fact, I guess, as the question was brought up about the south wall, which, when it was initially poured, was intended as a structural wall, and was poured in that way because of the fact that it was on the boundary line, and it is intended to be continue as a part of the new
Mr. Chair,
built structure.
excuse me, Mr. Chair, microphone. Microphone.
Oh, sit up, yeah.
Yeah, come closer to the mic, please.
Sorry. Any part you didn't get?
Move it closer if you
You can
want
move
to.
closer.
Oh, okay. Again, novice. So anyway, yeah, so that south wall is intended to be part of the new structure. It has rebar, was poured, and actually the city had to verify by having us cut part of it to show the rebar in it. So it was built as a structural wall initially, and it is going to be a continued part of the structure as a base for the elevated structure. So, yeah, as presented to you, we had pared back the size of it, and there is some conditional, I don't know how to get her drawings up here, but her,
What would you like?
well, and I don't know if that needs to be covered, but since I lost my house too, there was in that drawing that Tom did. Yeah, there you go.
You have to use the mouse.
The outline part here is a conditional rebuild of the house, which would be elevated above the parking spaces. And since that's in a floodplain, but that's not part of this, but that's also for future consideration, but that was also part of the fact. And is why we put this as a driveway here to get into the back. And as she said, yeah, we've been kind of hung up by the vacating jetty part as to where access to the property will be, and so we went with this plan, which seems to conform to most everything that we could address. The elevated part of the structure that you saw earlier, which is here in the back, is the office above, because there wasn't room to do it any other way. So other than that, yeah, I think it's pretty much straightforward. There has been a market selling on that spot since 1922. And unfortunately, the initial one was a little cottage burnt down in 1929. The structure that burnt was built in 1931. And I actually have pictures of it being built. And so I would like to continue, see if we can make it up to the century mark. And the fact that I've done it for my wife and I put the earnest money down for this in 1974, so we've been members of the community for a while. She has since passed away, but anyway, that's when we first came into town. It's 1974. And I kind of hate my legacy to be that we didn't replace this. So I don't know what else. I guess in some talk of the sidewalk. Sidewalk, though, which, some of it remains, which is in front of the old Moore store that ran out here. I don't know if anybody's old enough to remember the Moore store, but the Moore store, that sidewalk was poured by, I can't remember his first name, Huggins. He was a realtor here in town. He poured that sidewalk, so there is sidewalk in place. It wasn't put there by the city, but this is all sidewalk that I had replaced and re-poured in my duration there. And all of this sidewalk down here is new, probably needs to be resurfaced, but that's all fairly new concrete there. So, other than that, yeah, foot traffic there doesn't exactly line up with the sidewalks I guess the sidewalk project doesn't reach there in either direction, but at least I do have sidewalks in front to serve the customers. And I do expect, as somebody had earlier asked, if people are going to park out front. I think, yes. It is a wide enough egress there. There's a more than 10-foot wide shoulder there that I'm sure people will continue to use. I mean, I can't put that in my plans, but you also can't compel them not to park there. I mean, we did provide parking in the rear to comply with the Planning Commission requirement, but yeah, I think people will just park out front. So I don't think I have anything more dramatic.
Thank you. Are there any questions for the applicant?
Yeah.
Steve?
Is there a center turn lane on Highway 101?
Yes.
What percentage of the foundation is damaged? I read that you had intended to use the.
Well, right, because here on the sewer. Well, matter of fact, that's on this drawing.
Mm-hmm.
The sewer coming in is in place, and I guess as was brought up there was some infiltration. I think when after the fire and everything got excavated, part of the hub going to the sewer was damaged, and we haven't. But since we were thinking about rebuilding anyway,
Right.
Why repair this then? But all underneath here, there is the sewer line right there, and the water line is adjacent. The water meter, all of that infrastructure is in place, and they're in this concrete foundation. There are, I think, 5 or 6 floor sinks which survived the fire. All of that is in place. The water, sewer, all of that is in place under that slab.
Is that why the kitchen area is on that side of the drawings? Is that what you had the sinks and stuff? I was trying to find the pictures, but I couldn't find them.
Well,
You tried to make that plan to accommodate what was there.
This part right here would be the takeaway fish and chips. And there's a floor sink there, floor sink there, floor sink there, one over there, one here, and one over here.
Tried to reuse as much as you could.
Right. Yeah, since it's already in place. Yeah, and here the floor sink would be to serve as the service drains for the sink, which would be behind display cases, which were behind those, well, they weren't open in the drawings, but there's roll-up
A
doors.
few 8-foot roll-up doors.
Right,
Right.
which are there and there. And so, yeah, the sink would be right in here, and so, yeah, all of that infrastructure still exists and is functional.
Further questions? Thank you, sir.
Okay?
Right, do we have any testimony in support of the application? Do we have any testimony in opposition to the application? Others, including any testimony from representatives of public agencies? And no rebuttal by the applicant is necessary. ORS Section 197.763, paragraph 6A states that upon request, the commission must either grant a continuance for no less than 7 days or hold a record open for no less than 7 days to permit any participant an opportunity to provide additional testimony, argument, or evidence. Does any person who participated desire to request a continuance to provide additional testimony, argument, or evidence, or request that the record be left open to submit additional written testimony, argument, or evidence? Because no continuance is requested and no request has been made to hold the record open, is there a motion to close the public hearing and the record?
I move to close the public hearing and the record.
I second.
A roll call, please.
Griffiths,
Yes.
Hoagland, Cunningham,
Yes.
Robinson.
Yes.
Motion carries.
Thank you. Does the applicant waive the opportunity to submit final written argument after the close of the record as provided in ORS Section 197.763, paragraph 6E? Do you want to provide any more written argument or testimony? Or do you want to waive that opportunity?
If you waive it, the city planning commission can proceed and decide tonight. If you don't waive it, then they have to continue it for 7 days. And
Thank you. Does the city attorney or staff have any comments concerning legal issues raised during these proceedings, instructions on the applicable law, or legal advice concerning the application of the law to the evidence in the record? Sir?
the only thing I can, I guess, emphasize is that the code specifically authorizes you to impose conditions. Your staff recommended a condition about surveys. Aside from that, if you have any questions, I'll be happy to answer them.
Thank you. All right, this matter is returned to the table for deliberations and recommendations.
I move that we restore this unlawful, non-conforming mixed-use building on the site as long as the owner, Alan Black, provides a survey at the time of the footing inspection to demonstrate that the structure is not in the floodplain and does not cross property lines.
I'd second that motion.
We have a roll call, please.
Hoagland,
Yes.
Griffiths,
Yes.
Cunningham,
Yes.
Robinson.
Yes.
Motion carries.
All right, it's now 6:34. The public hearing and record for file ZOA 2016-05 remains open. This public hearing was opened on July 19th and concerns a city-initiated proposal to amend vacation rental dwelling land use regulations. Does any member of the commission wish to declare a conflict of interest in this matter?
Your Honor, I believe that at the last meeting, you continued the public hearing. So I think we're at the point where the public hearing, under the box, the public hearing remains open. And so the continued hearing is handled in the same manner as the original hearing. So you would continue with the script at that point.
Okay, the public hearing remains open, and any person may speak up to 3 minutes. If you wish to speak, please write your name and mailing address clearly on the sign-up list at the entrance. Please speak directly into the microphone and begin by stating your name only. If you also have written testimony to submit into the record, please provide a copy to the recorder. Was there a sign-up sheet? Anybody? Excuse me? Does the staff have any comments or updates to the original presentation?
Sorry?
Do you have comments or updates to the original presentation?
I did give you a revised staff report, which just is in writing what I gave you orally at the last meeting. And I think there are a couple of, I know there's at least one comment received today at your seat. I don't know if there were there others in the last 2 weeks?
Seen this one.
The only additional letter is the one that you have at your desk. Everything else was in the electronic packet.
Mr. Chairman,
Sure.
can we ask staff additional questions or not?
This is a continued public hearing, so you have a staff report and questions of staff, and then you have requests from the public to speak, because it's a continued public hearing.
So this,
As if we never,
It's handled in the same fashion as the initial hearing.
so we're dealing with the staff report as done, as complete. Does the commission have any questions for the staff? Shoot.
I have a couple. I was wondering, in the research you have done on other coastal communities in regard to this issue, do any of them allow VRDs as a permitted use in a residential zone? Or is this something new?
No, some do. Yeah, like at Newport, for example. It's a permitted use.
So there's no accessory use in Newport?
Not that I'm aware of.
And then could you explain a little bit more about the cap? It would be at 12%, and is that changeable or not changeable, or?
It is changeable. The proposal is 12%, which gives room for, I think 70 more than there are now. Again, this is just in the R15 zone. There's about 162 the last time we looked. This would allow up to 232. So if we started getting close to that cap, then my expectation is that we'd take a look and see whether we want to, actually the city council wants to change the cap, to increase the number.
So theoretically, if the future city councils change the cap and make it a higher percentage, we may actually never have a cap put in, really implemented then.
It's possible that you could never reach the cap.
Okay. And then the other question I have, what's the rationale for 30 days being accessory use as opposed to 29 days or 90 days or 120? What's the reasoning behind that?
That's a number that the council had looked at in the past and decided that that was appropriate. There was a long process that they went through where there was a staff report with various possibilities and options, and that's just a number that the council settled on. That's right, isn't it?
Essentially, the council adopted ordinance 2014-21 and 22 land use ordinances. They also adopted ordinance 2014-23, a license ordinance. While ordinance 22 and 23 were later not overturned, but rejected by the voters, ordinance 21 included all the associated land use findings. The findings included an analysis of what accessory use was. Basically, incidental and subordinate was a small number, and the council found as part of that 30 days was a small number consistent with the definition of accessory use. So there's support in existing ordinance because those findings are incorporated into ordinance 2014-21. There is support for 30 days as being accessory use consistent with the definition that existed, still exists. The council did also, in fairness, say that that may not be the only number to implement that discretionary land use standard, but certainly 30 days does implement that standard.
And then if the cap goes in place and is implemented in the R15 zone, theoretically there could be one home on a street is a VRD and can rent their VRD 365 nights a year. And right next to it could be another house that applied for a VRD license after the cap is reached. And they can only rent their VRD for 30 days a year, correct?
No, actually, they wouldn't, well, yeah, they could get an accessory use, 30 nights.
Right, so that would be kind of a double standard right in the same zone with regard to VRDs.
That's one way to look at it, yeah.
Okay, thank you.
The idea of the lower number, with the accessory use limitation, is that it has a lower impact on its neighborhood. And the idea of the cap, the 12%, is to make it so that VRDs don't come to dominate what is intended to be a residential zone.
Has there been a VRD license denied?
Yeah, I think we've denied one or two. What usually happens is people come in and say, and we go over it with them and tell them that if they're not going to be able to meet the standard, they shouldn't apply. They should save their money. And we tell them, we do tell them that why we don't think it can meet the standard. Of course, people are always free to apply if they disagree with us.
And how long have we been issuing VRD licenses?
Well, I've been here. We've been doing it at least since 96, maybe even before then. I've been here since 99, and we've been issuing them since then.
Has there been
Not licenses, but we've been allowing them to be established.
Is there a separate fee from the license to the application?
Yes.
Would there be a different license fee for the 30-day or the 360 unlimited?
There's no proposal to that effect, but it's possible that could be.
Has there ever been a VRD license revoked?
Been one.
After it's been revoked, has there been any kind of follow-up to assess what that house is doing?
What do you mean?
Let's say I have a VRD and it's set up to be a VRD. I have a license. You take it away from me, and I'm just going to keep operating it.
We keep track of that kind of thing. Actually, that house was sold.
What else?
Gary, do you have any questions?
I noticed that the trend for additional licenses seems to have leveled off or even started going downward in the last 2-3 years. Is that probably an impact of the economic uncertainty?
I think the main reason the number went down was because of the health and safety standards. There were some units that were unable to, or well, at least, or say the owner chose not to bring them into compliance due to the expense of coming into compliance. Principally, the idea of having conforming egress windows. I know of a house in my neighborhood where the owner at the time had it as a VRD. When they had to go through the health and safety standards, it didn't meet the standards, and they decided they didn't want to spend the money. They sold it, and the people that bought it decided they did want to spend the money. If they put in the appropriate egress windows, and it's a vacation rental again. But I think that's why the number probably dropped. Why it has been essentially level for several years or for a few years we'd have to speculate, but it could be in part, it could be we've reached market saturation, or it may be just uncertainty. People don't want to invest if they don't know what the law is going to be.
Is there a checklist, so to speak, to become a VRD that they have to apply? And if there is, what percentage of those qualifications must they meet in order to obtain the license?
There is a list of standards, and they have to meet 100% of them. You can't mostly meet them. You have to,
Well, I don't-
yeah.
Yeah. I think from your report on the housing, you mentioned that for non-VRD homes, the average household size is 3, is that correct?
This is actually it's less than 3.
Less than 3. What is the average occupancy of a VRD? I don't remember that.
The average, well, we don't know how many people stay in them, all the time. I think the average allowed occupancy is, I think it's more than 10. I want to say, I don't remember exactly what it is, but I think it's more than 10.
Thank you.
I don't think I have that. It's in the report, which unfortunately I don't think I have in front of me.
Commissioner Hinton,
I think we might be able to get you an answer here.
Has-
Okay. I've got it. In the average family size in Lincoln City is 2.74 people, and the average household size is 2.14 people.
Which,
Household
where is
is
this information from?
U.S. Census.
2010?
Pardon me?
From 2010?
Actually, it's from the, yes, it is from the 2010 census, yes. Okay, what I've got here is that people put down the occupancy that they want to have, and it's ranged from 2 to 42. And most common is 10, for 66 VRDs, 8 for 58 VRDs, and so on. The 44.7% can accommodate more than 11. So you can figure roughly 10 or 11 is probably the average size.
Thank you.
I have a couple of questions. The idea of 2 + 1 on the, how did we come up with that on the bedrooms versus the people occupying that?
That's a license question, isn't it? Isn't that a city council
That's
question?
in the licensing. We're talking about,
You'll have no say on that.
No, that's not a part of our jurisdiction.
it's not part of what
this
you're
issue.
looking at tonight.
Okay? Okay, I've got another question on
I can
it.
answer that some communities have that, and that's one possibility that came up at the city council.
Okay, because,
But that, again, that's not what you're here for tonight.
okay, then I won't go anywhere on that one. Commissioner Hinton brought up something last hearing where we were talking about this, where she mentioned the fact that Rhodes End is proportionately higher, significantly higher in BRDs versus residents. And at some point in time, we have a number here for Lincoln City, and we have this group that's not being part of that will be brought in. And all of a sudden, we're going to have a lot more VRDs than we have now, and I guess that will require us to re-rate everything, or will we treat Rhodes End as a separate entity on an ongoing basis?
What I expect will happen when we rezone Rhodes End, which of course is part of the city, so the VRDs that are here are part of the city. When we rezone Rhodes End, I expect it to have its own zone, maybe part of the R1 zone, but it likely, we have 3 R1 zones, the R15, R175, R110. I expect there to be a 4th roads, or R1 zone.
R1RE?
Exactly. For Rhodes End.
And we can keep
And
that
then
out of this
in
equation.
this, in the zoning here, where we say a 12% cap for the R15, I expect, and we would say, and for the R1RE or whatever it is, the cap would be some other percentage.
I was concerned that would make things, I guess the other thing that bothers me is he brought about disparity neighbor to neighbor, but it can also be looked at as neighborhood to neighborhood, because where we put a cap on in a whole zone, we could end up with concentrated areas where VRDs dominate a residential area and almost put them out of, and it's no longer residential, and other areas could be ignored, and they get off the hook. Or I'm trying to figure out how we make this a level playing field if we're going to apply rules to this zone, how we can treat everybody equally that are residents in these zones. Because I have a friend that everybody in the world has moved a VRD into his neighborhood. Now, I don't get into specifics with him, but, he talks about the day that he moved in and how 25 years later, everybody's a VRD now. And I don't, like I said, I don't talk specifics with him because I don't want to get into that ex parte kind of thing. But his viewpoint is that, this is happening to me. Everybody else is getting by.
Gary, is there a question in that?
Yeah, I'm trying to ask, is there a way that we could level that playing field out? Is there a way that we can make this work so that I don't know, I guess slicing up R15 zones so that they're somewhat proportionate? I guess that can't be worked.
Well, actually, what this overall proposal does, in a way, it does that by slicing off the R15 from the R175, where in the R175, it would just be an accessory use. Same thing for the RM and other residential zones. It's just saying in the R15, this is where we're going to allow them. So it's for where you draw the line, and that's fundamentally what zoning's about. It's drawing lines. And, you're on one side of the line or the other, and depending on your philosophy or your feelings about things, being on one side could be either a win or a loss, depending on how you feel about it, an individual issue.
I'm uncomfortable with the suggestion of getting rid of accessory use in the R15 zones, especially since you said that, the occupancy of VRDs is often 3 times more than the average household size in those residential neighborhoods. And allowing them to be rented 365 days a night will just increase the number of people in those residential neighborhoods, and it will greatly increase the amount of traffic. And I think if we're going to use accessory use in the R17 zones, we should also apply it to the R15 zones. It doesn't have to be 30 days. I think that should be revisited. It should be increased, but
Steve?
I would not allow it as a permitted use.
We're not in deliberation, though. We haven't had testimony from the public. We should just be asking questions of the staff.
So I guess what was the
Testifying.
rationale again for not using accessory use in the R15 zones?
I'm going to give a two-part answer to that. One is, you still could have a VRD as an accessory use in the R15 zone. I just want to make that clear. They still would be there. The rationale for allowing as an allowed use 365 nights a year is essentially that's where the market is saying it wants them to be. Yeah, the city manager is saying it's recognizing it's already taken place.
Can you give me again the housing for R110, R175, 1.5, the number of homes and the number of VRDs for each of those 3 zones?
No. I think the R110 is pretty easy. I think the number of houses is 0, or it might be 1 or 2. There's very few because it's a very small zone. I don't think there are any VRDs in that zone. In the R175, I forget how many dwelling units there are, but there's, I think, around 30 VRDs in that zone. In the R15 zone, there are about 162 VRDs, and I know there's 1,940 lots in that zone. I forget what percentage of those have houses on them. The vast majority of the VRDs are in the R15, in residential zones, are in the R15 zone.
I have a question for Richard.
Keep in mind, we're only asking questions at this point for public hearing.
Okay.
When you get to deliberations, you can ask your staff to help you apply the facts to the law. Then but if you need evidence, this is the time to ask staff for evidence.
That's not evidence.
Are there any other questions?
I'm going to try and see if I'm in the wrong area again. Richard Apicillo, you explained the distinction between taking a property and the fact that people still have a right to use their property in some way. Are we dangerously close when we limit somebody to 60 days of renting their property that they built with the intent of renting for 365 days? Or is that a different time to ask that question?
Well, in terms of evidence and testimony, I mentioned Ordinance 2014-21 and the attached findings document, Exhibit A and Exhibit 1 to Exhibit A, which talks about the accessory use limit. And those findings documents addressed allegations of takings, which is what I believe you're referring to, when the city proposed to limit, proposed regulations in 2014 concerning limiting the use of properties to not allow commercial level of VRD use in residential zones. So basically implementing accessory use. There was allegations that you were taking all reasonable use of the property, and the city relied upon Cannon Beach case, where Cannon Beach, and I think we cited both the appellate court, the Court of Appeals, as well as the Supreme Court, and maybe even the Luba opinion, basically holding that not being able to do a VRD, short-term rental, is not a taking, because you still have a house which you can use for residential purposes, for yourself, or for long-term rental. So in terms of constitutional takings allegations, regulating vacation rentals, short-term use is not a constitutional taking.
Thank you.
Thank you, Mr. Cherokee. If I can respond a little bit more to Commissioner Hoagland's question. It is in one of the reports that I wrote, actually. So in the R15 zone, at the time this was written, there was 173 VRDs. In the R175, there were 12. In the RR, the recreation residential zone, there was 1. In the Nelscott Cottage residential zone, there were 5. In the RM, the multifamily residential zone, there were 20. And in Rhodes End, there's 176.
Okay, thank you. I have clarification. In this report, the Lincoln City Housing Summary, it says total dwelling units 5,581, occupied, which was defined as someone lives there more or less full-time. Is that, and then the other one is vacant, which is occasionally lives there. So vacant, it says 2015, would those 2015 houses be eligible for VRD status? And then
Yes.
of that,
Well-
renter occupied, is that VRD? And owner occupied, is that VRD? So it's not clear if the owner owns it and they stay in it. I mean, it looks like it's easy to see, but it also could be that, they're just vacant and being rented as well. And that doesn't add up to the 190, whatever we just said in that residential zone. That's a big difference from 2,000 to 200.
Remember the 2,000 so-called vacant, that's citywide in all zones.
And what you just told us was just in the
In residential
zones.
zones. And there's about 2,000 so-called, 2015 so-called vacant, which are, if you look, there's several reasons why they're considered vacant.
Right, sold for sale.
They're for
rented,
rent.
occupied. Right, but
And so on.
for
But,
sale could be rented. Houses for sale
sure,
could be,
sure.
I mean, that's what happens.
But what it's saying here is that if someone's living in it, it's not considered vacant, even if it's for sale. If it's vacant, no one's living in it, and it's for sale, it's counted as vacant. Also counted as vacant are people's second homes. And there's about 1,600 of them, according to this. Of those 1,600, 460, 70 are VRDs.
So there's just 1,200 houses just doing nothing.
Well, they're not doing
But this-
nothing, they're
that's what this-
somebody's
that's what this-
second homes.
But yeah. Okay.
I think Mr. Chandler said earlier that the permitted use was for, reflects current reality. My question is, but VRDs in the R15 zones have not been able to rent 365 days a year up to this point in time, right? They've only been able to, it's only always been accessory use.
Currently,
Functionally, yes, it is an accessory use, but the question is, what does accessory use actually mean? We do have, and so over the years, that has not been well enforced and well established, so people have been renting it at different levels. We have some that have been permitted, that we do have some licenses that are permitted very low. We do have some licenses that are permitted up to 300 days under the accessory use law. What this, the intent of the ordinance that you're looking at, it does a few things. One is to recognize a little bit of what the market has already said. And the market is established where VRDs are desirable, and that is west of Highway 101. And it is predominantly in the Rhodes End area or in the R15 zones. And so so what we're looking at is a little bit of recognizing that is what the market has already established. That's why when you'll see on that the R175 only allows for the accessory use, which is being defined as 30 days. You can look on a map and say, if I don't want to live around VRDs, I can go to this zone. If I do want to live around VRDs or own VRDs, I can go to this zone. Very traditional zoning. It also attempts to recognize that there is an impact in the neighborhoods by having a commercial use, which is what a VRD is, in a residential zone. And that is the reason for the cap, is that it ultimately is an attempt to protect the residential nature of the zone by not allowing it to go, by not allowing it to be completely VRD dominated. And so that's the purpose of the cap. It's a balancing act between those that would use the R15 zone as a commercial purpose and those that would use the R15 zone as a residential purpose.
Answer your question? Thank you, sir. Any further questions? Thank you. Thank you, sir. Now is the time for public comment and testimony. Please state your name only. Robert Hertert?
Good evening, Chairman Robinson and Commission. My name is Robert Hertert. City Council is making decisions about VRD license transfer at the same time that the Planning Commission is making decisions about implementing a cap on the total number of VRDs. We object to the separation of these issues. We recognize that the cap is a land use issue and needs to be considered by the Planning Commission. However, the license transfer issue and the VRD cap are inseparable in their impact on property owners. We maintain that your recommendation on a VRD cap should have preceded the deliberations by City Council on license transfer so that City Council can make appropriate decisions on the two of them put together. In the first meeting of this hearing, the planning director presented his rationale in coming up with a 12% of R15 lots as initial VRD cap. And we agree with his goal of the 44% expansion room for new VRDs so that the real estate market is not further damaged. But we disagree with the initial assumptions. Let me hand out, if I can just have a minute to hand out a number sheet so that you all can follow along with me. Is that okay, Chairman? Yes. This is just basically a mathematical thing, but in going through in going through the information last time, the number of 162 VRDs, which is the current number in the R15 zone, is what was used. And when you use the 12% of all the lots, you subtract that to get the number of new VRDs that would be allowed for expansion, it does show a 44% expansion room. So, we agree with that. But if you look at the past 8 years, the graph that Mr. Townsend showed at the last meeting, for those 8 years, the average was closer to 190 or 191 VRDs in the R15 zone. And so when you take that same 12%, there's only 42 allowable new VRDs, and really it's only half the percent growth that I think was intended to allow the cap. And that growth, I know, is well recognized by planning and the city manager, but that growth is what will keep the real estate market from being torpedoed, and the uncertainty that we've already heard about tonight, and why those numbers lowered over the years is, in my mind, directly tied into the uncertainty of the real estate market. No one wants to buy a house if they want to use it as a BRD and they don't know they're going to be able to do that after the transaction. May I have another minute?
Yes, please, go ahead.
Okay, thank you. We'd like to also bring up what confidence can we have that similar growth opportunity will be provided for Rhodes End when it is melded into these regulations. And the non-transferability of VRD licenses drives the need for expansion room. So these two issues are so tied together, the fact that we can't transfer the license, or that's being proposed, and this cap. And finally, we believe that the landscaping requirements of 50% of the front yard for VRDs will aggravate the parking problem identified by Mr. Chandler as the most significant and difficult problem he's found during his citywide workshops. Why make it worse? If the end goal is to simply eliminate VRDs not meeting the requirement, we point out the discrimination against VRDs. We agree it should be listed as a goal but not as a requirement. And why should this landscaping percent requirement only apply to VRDs? Why not second homes and permanent residents?
Any questions for Mr. Herter?
Just to be clear, that you said that the 22% is negative if we use that as a real number, not just the historical low, and that we should reconsider that to be a larger number, more than 12%, to make that the condition on buying a house with the intent to make it a VRD, just to be clear. So it's the real estate market.
Yes.
So that you will buy a home, which is just a home, in order to turn it into a business. We're trying to mitigate the problem associated with there being too many VRDs or not enough VRDs.
Well, and I think what we've heard tonight is it is a balance from Mr. Chandler and Mr. Townsend, that it is a balance, and that what is trying to be accomplished is to recognize that you have VRDs there now, and if for example today there was a cap put on the exact number of VRDs that exist there, every owner of every VRD who wanted to sell their house wouldn't, it has a huge effect on the saleability of the houses.
I think that selling a house is kind of misleading because you're selling a business.
Partially. We live in our house part-time, and we use it also as a VRD. It's a family house. We were down,
I'm just saying, I would also like to make it clear that you are saying that the 44% is not enough.
No, I'm not saying that.
You're just providing some
I'm
information.
just, the information I'm providing is that 40% growth was derived, the 12% number came from a desired 44% headroom over the existing, and that 12% should be like 14 if you want to
To
provide that.
accommodate the real number of the last 8 years.
Right. Anyway, that's just my recommendation.
I didn't understand which way you're going, so I just wanted to make sure.
Are there any other questions, gentlemen? Thank you, sir. Any other testimony?
Commission, Debbie Williams. I have a question about the 12% cap. What, and I don't know if you can answer the question, the problem that we're trying to solve with a cap is so that it doesn't proliferate over a certain number in the city. Is that correct? So we're not answering questions. So we have,
I was just trying to figure out the format here. Did you have testimony?
yeah.
Okay.
So this directly relates to the cap, but if we're trying to problem solve, and if VRDs are in essence a problem, and then we think that limiting the number of them will solve the problem, what is to keep the people that do have their legal VRDs from creating havoc just as much as a 30-day rental can create havoc? We don't micromanage the 30-day rentals. Why are we micromanaging vacation rental dwellings? Why don't we just have a set of rules that allow them to work in the community, and if they do not live up to the set of rules, they lose their VRD or they get fined a certain amount of, I just don't understand the micromanagement and what it is. Personally, I have evidence of what it's doing to the real estate market because I am a principal managing broker and I see thousands of transactions. And we have had several transactions that have died because they can't get anything more than a 90-day permit right now. And since the inception of VRDs and licensing them, we have never gone over a certain percentage. What makes us think that that is going to blossom into a 60% or a 50% or a 40%? It is a very difficult thing to do, to have a VRD. It costs a lot of money to have a VRD. It takes a lot of maintenance to have a VRD. And there are a lot of people that no longer think it's worth it. And the reason that we have lost several of them is because they've gotten tired of this. Not just because they couldn't live up to the health and safety standards. They are tired of Lincoln City and what it is doing to the home that they wanted to eventually retire to. And many, I've got transaction after transaction that happened with, not me personally, but within my office. I've had a couple of them personally also. But I really think that we are going the wrong direction in micromanaging instead of educating. And that is something we really haven't addressed enough, is education of those people that are getting licenses, those people that are using VRDs. And when we talk about saturation of VRDs versus second homes, are we trying to say that we should mandate that second homes allow their homes to be rented as a 30-day rental? I don't think that's what you're saying, but it sometimes sounds like that when I'm listening out in the audience. Anyway, it's just my 2 cents. I think we're going in the wrong direction with
Thank you.
The cap.
Questions for Ms. Williams? Thank you.
Okay.
Is there any other testimony? If there's no further comment, is there a motion to close the public hearing and the record?
Make a motion to close the public hearing and our hearing in the public record.
Second?
We have a roll call, please.
Griffiths,
Yes.
Cunningham,
Yes.
Oakland,
Yes.
Robinson.
Yes.
Motion carries.
All right.
Don't you need to jump in here?
Well, just technically, this is a legislative matter, and it's the record, you make a recommendation to the city council, so the record will remain open through the city council meeting. Now, the hearing's closed, and you're not going to be taking any more evidence prior to your deliberations. So in a sense, you're saying, okay, we're going to deliberate based on what we've received up to now.
Right.
But the council will be able to accept additional testimony and evidence.
Should I restate it to close the public? Should I restate my?
I think with that clarification that I stated, I think you're okay.
I think we're fine.
Do you disagree, Richard?
No, I think what you're saying is right. So,
Just didn't want people to think they couldn't send letters to the city council and show up at the council meeting, so.
All right, we are returned to the table for discussion and deliberation. Gentlemen?
If you want, I'd like to just say just a few things just about what you're here to do. This is a legislative matter, so in any amendment, and you're amending Title 17, so in terms of the applicable law, Title 17 includes Section 1788, which talks about amendments to the code, and your role under the code is to make a recommendation to the city council. The city council cannot adopt an amendment to Title 17 without making findings, and those findings must concern the consistency of the proposed amendments with the adopted comprehensive plan and this title, Title 17. So you have a review of the proposed amendments against the comprehensive plan and a review of the proposed amendments against this Title 17 internal consistency, basically. So that's your principal factor. Now, you also have statewide planning goals where we don't have a specific provision or guidance on a matter, then you can resort to and look at the state consistency with the statewide planning goals as well. So at first, you look at our comprehensive plan goals and policies. And if you don't have enough guidance there, you can look at statewide planning goals. So I suggest that you go through, well, if you haven't done so already, look at each one of the amendments that's proposed and analyze them for consistency with the comprehensive plan and consistency with the zoning code itself. So if you want me to help you through that, I can do that. If you just want to talk about it amongst yourselves, you also are down 2 members, so if you want to.
No, your guidance will be welcome.
Okay.
Gentlemen?
I start by asking, what legal issues happens if we create an unlimited VRD rental versus what has been established now that we start something different? Will there be backlash?
So your question is specific to, well, there's two amendments proposed here in this text which authorize unlimited rentals. So the first one would be where the code says in this proposed amendment that you can,
Like Section 4 and 5, 6?
well, it specifically has to do with Section 2, which is an amendment to the R1, which authorizes both accessory and permitted VRD use in the R15. And then more specifically under the Sections 9 of the ordinance, I think it's 9.
Yeah, we are allowed as accessory use, and those would be.
Yeah, it's R15 is listed as a permitted use, and then it has that subset C, which has the 12% cap. And then there's another section that basically says, I think it's Section 10, that says if you have an existing vacation rental, you are allowed, it actually says may continue to operate without the accessory use limit, which I believe is incorrect. There is an accessory use limit in place now. So there's 2 places in the code where unlimited vacation rental in residential zone is being authorized. It's always been permitted to be unlimited in commercial zones. And it just says commercial zones. And so the list of zones now in Section 9, which are listed as where it's permitted, include a lot of commercial and mixed-use zones. So that's been clarified. But the change in Section 2 and in Section 10, which basically says in R1-5, VRDs are now a permitted use, and I believe there's about 180 existing VRDs in R1-5.
It's actually Section 1 says they're permitted.
I'm sorry, you're right, Section 1. And then in Section 10, where it says all the existing VRDs throughout the rest of the city are allowed to continue until transfer. So those two sections. So you asked what legal issues are presented. The legal issue is what comprehensive plan policy is implemented through the amendment to the R1-5 to allow all VRDs in the R1-5 to be unlimited as to rental nights, subject to the cap. So about 250 based on the 260 maybe based on the current numbers. 260 VRDs in R1-5 will be unlimited basically when the cap is reached. And then what comprehensive plan policies are implemented by saying in Section 10 that existing VRDs, which currently have an accessory use limit, may operate without limits until transfer. Those questions are for you to answer. What policies are being implemented through those amendments?
Just correct one thing, it's 232, not 250 or 260.
Is there a number, 232 includes all vacation rentals, whether or not it's accessory or full-time?
No. The 232 is the number of, at 12% is the number of VRDs that would be allowed in the R1-5 zone to have an unlimited number of rental nights. Every other dwelling unit in the R1-5 zone, the way this draft is written, also could have 30 nights per year.
You could look at this as this proposed amendment removes the accessory use limit for 232 VRDs in the R1-5 zone. Removing the accessory use limit, okay, the accessory use limit, if you recall from ordinance 2014-21 and 22, that implements the comprehensive plan policy to, and the zoning R1-5 policy to restrict incompatible uses in the residential zone to basically make them more compatible by limiting them through the accessory use limit. So question for you is, how are you consistent with that policy by removing the limit for 232?
Doesn't seem to me like we are.
And that's for you to decide, but specifically if you read the purposes of the R1, again, internal consistency and comprehensive plan consistency. You measure the amendments against the comprehensive plan. That's what Oregon land use law requires you to do. That's what your code, Section 1788, requires you to do. So the purposes of the R1-5 is to promote and encourage a suitable environment for family living and to protect and stabilize the residential characteristics of the zone. The R1-5 zone is intended to provide primarily for single-family dwellings. That's what the purposes of the 1716-010, that's R1 purposes. Okay, that section mirrors the comprehensive plan policy about protecting and stabilizing residential areas by protecting them from incompatible uses. So in all of these amendments, you simply ask, what policies are we implementing in the comprehensive plan? Removing the accessory use limit implemented this policy. We're proposing to remove the accessory use limit and replace it with a cap. Does the cap, this is the question for you, does the cap substitute for the accessory use limit in protecting residential areas from incompatible uses. We had someone come up and ask whether or not, what's the purpose of the cap? You could find that the purpose of the cap is to substitute for the accessory use limit as a mechanism to make compatible the use.
We can also add that the comprehensive plan's economy goals talk about supporting the tourism industry in the city. So in a sense, there's some tension between the housing goal of protecting the residential character and the economic goal about supporting the tourism industry. So by accommodating the tourism industry to some level in the residential zone, you could interpret that as an attempt to balance the requirements of both of those comprehensive plan goals.
Richard is correct in that there is another comprehensive plan policy in the economy goal about tourism and promoting tourism and balancing the economy goal and tourism against the housing element and making available adequate housing.
Sir.
Thank you. I also think that you don't want to look at this too narrowly, but you need to look at the whole thing as a whole of the ordinance. So when you're looking at how does this meet your residential goals in the comprehensive plan, you also have to ask what you've got. Over the last 20 years, you've used an accessory use without a definition as to exactly what it is. That has allowed for the proliferation of VRDs that are rented anywhere from a short period of time, rented up to 300 days. When you're looking at this as trying to meet the goals of the comprehensive housing goals, which is the protection of the neighborhoods, you're saying that we're going to define what accessory use is. For those that have been operating under this, we're not going to punish them by telling them that they're going to have to shut back down to 30 days, so we're going to allow that to continue. And you're going to limit the total number so that VRDs do not have the potential of becoming the dominant housing type in the R15 zone. So it's, if you try to go and just say, how does each individual provision, you're going to run into some problems. But when you look at it as a whole and how they interrelate with each other, the cap interrelates with the accessory use, which interrelates with the other provisions, then with the financial provisions that Richard means, then you have a much better idea of why this is taking place.
Thank you. Any questions for City Manager? Gentlemen?
Yeah, I'm comparing, I looked at the comprehensive plan, and it's got a number of different goals, and included among them is the city shall work to stabilize and protect existing residential areas from deterioration and incompatible development, increase the amount of decent and affordable housing, especially rentals available to lower income households, increase the amount of lower cost rental housing available to the elderly, and decrease the proportion of income which the elderly spend on housing. And I think as a management tool, I'm not convinced the cap will be ever effective. I think, you know, the percentage may be raised by future city councils. I'm not, and I think the fact that accessory use has not been implemented in the past or not effectively doesn't mean it can't be in the future. I think 30 days is way too low. I think it should be defined at a much higher limit. But I think it should be maintained in all of the residential zones in order to maintain that value of what a residential zone is. And I think if we go to VRDs being a permitted use in an R15 zone, that will lead to gentrification of some of the older neighborhoods in Melscott, for example, and also in Cutler City, which now probably a good portion of them, I don't know exactly how many, serve as monthly rentals for people who work in the city, and are affordable monthly rentals. And, you know, if those areas are gentrified, Lincoln City will lose a lot of its residential charm, I think. And making VRDs a permitted use will encourage developers to build VRDs rather than other types of housing. And I think one of the concerns we need to have to make sure what we do is in sync with a comprehensive plan is to maintain the diversity of our housing options in our residential zones. And I think making VRDs a permitted use would not do that.
Get rid of the cap.
The microphone.
You were
I
saying,
think the cap is not as an effective management tool as implementing accessory use and making sure accessory use works. I think that's a management tool we shouldn't give away.
well, I guess what I'm getting at is why the cap wouldn't work, because if the cap's, you know, based off of licensing, and they get 40 more in, they can't build anymore. I mean, they're done. They can't build
The
any
cap
more
percentage can be
RDs.
increased easily.
Oh, okay,
Yeah.
yeah, but I mean, if you have the cap and you say that's what the cap is, unless somebody comes along to move the cap, it does work, because it's got a ceiling.
It seemed like there's some kind of an inconsistency between the 2 points of if you have a cap, how does that, how then are we going to be gentrifying these other neighborhoods? It seems like the cap would actually go to reduce the gentrification of the other neighborhoods in that zone.
I don't think so, because in the R15 zone right now, if we go with the 12%, many more VRDs can be built, and they're going to be built in the R15 zones. It's going to change the nature of those neighborhoods.
So are you recommending a lower cap?
I just think we should look at keeping the accessory use, and maybe, and I think the other point Deanna raised, or one point Deanna raised at our last discussion was, you know, with the R7 and the R5 and having different standards for those two residential zones, you're creating, you know, east side versus west side, you know, this residential zone versus another in terms of how we manage VRDs. And I think there's just something about that that doesn't work.
I agree. I kind of like what they were saying, though. The market's pretty much the driver of that. I mean, do you want, I mean, you can say, okay, we're going to treat it all evenly, but in reality, they want to build VRDs close to the ocean. They don't want to build VRDs on the east side of Devil's Lake, you know, because nobody cares about having a VRD on the east side of Devil's Lake. And you know, I'm a resident. I have a piece of property in the commercial, so I can do whatever I want with mine. But I came here to rent. I came here because I rented VRDs. I enjoyed the experience of bringing my family together in a VRD, and it was in Rhodes End most of the time, but it was here in Lincoln City, and we had a great experience. We didn't trash anything. We didn't park but 2 cars on the property with 18 people, whatever, you know, we pile them all in the cars to get here. And it was a good experience because it was in a residential neighborhood, and it wasn't in a motel room, and we could have a family experience in a neighborhood. I enjoyed that.
I think that
I don't want to turn that away from everybody else in the future because I got my piece
Well,
of the
I think
pie.
you're right. I think visitors enjoy being in residential neighborhoods, but I think, you know, we need to make sure they remain residential neighborhoods.
So the market decides that most of the VRDs is in 1.5. What does it matter if we allow the same things in all the other residential zones? It wouldn't matter because they wouldn't go there. But at least we would treat it all the same. Sure. You're using this market as the why it should only be in this one area. Let it be across all the zones, and let it apply there, and they'll go where they will. Why does it have to be this one thing? If they don't go to RR or R175, fine. But the standard would apply to all residential zones.
I like that. If you make that 12% cap and everything like that, so nobody ever occupies it.
What does it matter?
Does it matter, and we're playing fair with everybody?
Well, you would be, so if you include the R175 zone in it, and it's better to have a VRD in the R15 zone, now have just increased it probably to about 500 VRDs that could be located in the
no.
R15 zone.
But if we kept them as zones at those numbers, though, that's 12% in the R15. So everybody's being treated
You mean you have a separate cap for each zone?
Sure. Everybody's being treated equally, whatever the zone you might want to call it. Does that create a problem as long as we stay with equal per zone?
Why isn't it? I don't know why it couldn't be, you have this ideal 12%, let's just say,
1 in 8.
12% of the city, okay, is VRDs. Fine. Of that, R15 is more, so they're going to take up, 60% of that 12%. And R175 takes up 2% of that, 12%. I don't know why, if you're trying to be even.
If you
it's
do
not.
if you do a citywide cap, okay, then you will have the greater concentrations than 12% in an R15 zone.
But then,
But if we don't, if we do it by
and
zone,
then it shows.
But if you do it by zone, then yes, if you say R15 zone gets 12%, R175 gets 3%.
Or 12, no.
Or, I'm sorry, 12%, but they don't cross over.
Right.
Yes.
It's more transparent. If the city is really 40% VRDs, if you look at it total, then it's really 40%. And it's not 12% of this neighborhood and 60% of that neighborhood and 14% of that neighborhood. Let's be a city instead of, again, making it these separate things and no.
Now, they're going to the beach,
Right.
right? They want to rent at the beach. Now, we can jam them into the east side of the lake or somewhere else through these mechanisms, but they want to go to the beach.
Or they'll go somewhere else because we can't figure it out.
Can't figure it out?
If we can't figure it out.
but I have another point to make, too. I think we talk about being true to the comprehensive goals and recognizing that we need to achieve a balance in our economy. And true, VRDs, people want to go to the beach, but retirees also want to live at the beach. And I think retirees, I think in one of Rich's report, indicate they make up 28% of our population are retirees, and they make up a significant part of the economy. And they support parts of the economy that people who come and spend the weekend here in the VRD don't support. And I think if we're looking for a balance, we need to make the west side of 101 as attractive to retirees as we do to visitors. And we've got to keep that balance. And I'm not sure, I think we need to focus on that, too. We can't ignore that, because that's part of our economy, and it's part of, we need to keep those areas west of 101 attractive to potential home buyers, whether they're VRDs or retirees.
Caps do that. To me, it seems like that's what the caps, that's the goal of the cap here, is to keep the neighborhoods balanced. So you're going to have this 12% of VRDs on that side of the highway.
And 44% increase in VRDs in R1 zones if that cap is implemented at that percentage.
Well, why don't we recommend making it 10% then instead of 12? Reduce the cap.
I'd like to see the figures for that, how that would work.
I would like to throw in, too, that if you decided on a cap, or the city council decided to implement that requirement, they could put a stipulation in there, I believe, couldn't they, Richard Apicello, that they cannot revisit it for a certain number of years?
Well, I think you could write that, but in any properly advertised amendment to the code, you can change the code. If you put something like that in the comprehensive plan, that would make it a little more difficult, I believe. But again, I think the main issue is just what comprehensive plan policy are you implementing? What zoning code policy are you implementing? If you think the cap substitutes adequately for accessory use in addressing the protection of existing residential neighborhoods from incompatible uses, then you make that finding, or you recommend that finding to the council, and the council gets to consider it. Ultimately, you're the ones who have to decide. So with each one of these sections, and if you look at our prior findings on the prior ordinances we adopted, we go through each section and talk about the consistency of the proposed amendment with the comprehensive plan. And of course, we realize that the whole thing is all tied together. There's sections here that say accessory use is now defined as 30 days, and you have a lot of evidence about how the accessory use limitation has historically been used to implement the comprehensive plan policy on incompatible uses. And so defining it and taking it out of the discretionary land use realm and putting it into a numeric limitation just makes enforcement easier. And we've talked about doing that in the past. So you have some parts of this are easily identified in terms of how they address the comprehensive plan. And you look at the whole as a balance.
Would the city council have flexibility over the 30 days? Yeah.
I'm sorry.
Can you speak into your microphone?
The city council have the same flexibility over the cap, over the accessory use limits as they would have over the cap. It seems like a couple of tools we can use to balance these various
The other thing that-
conflicting interests.
Aren't we?
Raise the accessory use limit, lower the cap, raise the cap, based on the outrage of the real estate community. If they start losing a lot of business, we hear a lot more about it.
Well, I think with the accessory use, you couldn't increase it more than 180 days a year, but
180?
or what, a half of 300.
Oh, yeah.
Yeah. But we're redoing the comprehensive plan this year, correct? So that,
Market?
huh?
Was there housing, affordable housing?
We're doing a housing study and economic study right now.
Right.
But I think if we went with the cap, we could put something in the new comprehensive plan that said that could not be revisited for 5 years or 6 years or whatever. Is that correct?
The suggestion I would make on that, and this is one I actually really agree with you on this, is that it should be reviewed with the comprehensive plan. That's the appropriate time to review a cap, is when you're reviewing a comprehensive plan, because cities aren't static. They're growing. They're things with a life of their own. And so it makes sense to review things when you do review them with the comprehensive plan. So adding that in, that that the comprehensive plan says, this should be reviewed only with the comprehensive plan, to me makes a lot of sense.
Are we approving each of these sections individually, or as the ordinance as one?
You recommend an ordinance to the city council. It's proposed as a comprehensive way to address this issue. So what I'm saying is, however, when you do an analysis of any ordinance, you need to look at its consistency with the comprehensive plan, its consistency, internal consistency with the zoning code. So you can say, okay, this section here that limits and defines accessory use to 30 days, that's implementing the comprehensive plan policy to protect existing residential areas from incompatible uses. This section over here, which says all the existing VRDs can operate at an unlimited level, that's implementing what? you know, the policies on the economy for visitors, to vacationers to have a place to go.
Started at the very basic foundation of what it's going to be built off of
Yeah.
this.
You
If
need-
this isn't met, then what is this up here?
Yeah, I mean, you could say this policy addresses this, and not every section can address every policy, but as a whole, the thing needs to be consistent with your comprehensive plan.
Well, I think that's the question. Is it consistent with the comprehensive plan, this ordinance? We've got to figure that one out. That's what we're here for.
All right, I think we need to take them a piece at a time and address that specific question, and I'm listing, I'm listing here the 30-day limit with the caps, the landscaping, the transfer, and the removal of accessory use in the zone. Are those the bullet items you would select?
And the
Say those four again, please.
I heard about the transfer. I'm not sure that transfer.
Transfer's not in this.
Good, thank you. I have landscaping caps, 30 days, and unlimited, removing accessory use. So do you want to take one of those and start chewing on it? What's the relationship between the 30-day limit and the comprehensive plan? Does it implement the comprehensive plan supporting the residential use, the character of the residential neighborhood?
okay, fine, 30 days, right? We look at 30 days like it's a month, like you are going to rent it out for July. And the rest of the time, it could be something else. And that's, I don't feel that that's a real thing. So it's 10 3-day weekends, is what I'm saying. And so if you have 10 3-day weekends, that's a significant amount of time, you know, so you're.
As an accessory use.
You're extending it more than a month, you know, it's not just a month. You can do that, you know, and so I think that that's, you know, and you want to make sure that those who have it as a business are able to cover their costs. And can you, at 30 days, at $200 a day, or whatever the price is that going to help them cover that? You know, so you have to look at it from that side, too. So is 10 30-day weekends at $250 a night going to cover their mortgage, their fees, and all that other stuff? I don't know.
Well, I was looking at it from the perspective of 30-day limit is 15 weekends. Somebody who lives in a neighborhood that has 7 VRDs in a 2-block area is looking at, 95 nights where there's cars parked and
That
VRD's
protect you.
usage, and is that too much, not enough, or an appropriate amount for a resident in a residential neighborhood?
It depends on how much of a community in a neighborhood we want to establish. Do you want it to be a neighborhood, or do you want it to be businesses? Where is it? How much do we need? Do we have enough hotel rooms? Is there already enough VRDs? How many more people? How much money do they have to make? You're making money, sure. Is it enough? There's lots of things that it's very costly to run a VRD.
So relate that to the comprehensive plan,
It depends on who you're going from, on whose perspective. Is it from
Well,
the-
I was addressing the aspect of the comprehensive plan that's about residential, people living in residence, in residential neighborhoods.
Right. I don't think that it would protect that.
30 days. Do you think 15 days is better?
As how you described you having 95, you know, with 15 days.
Yeah, my personal experience aside, I was just picking that out as an example. I mean, Rhodes End is unique.
What's the cost?
I'm sorry?
What's the cost of it being protection? Where is the line that you're protecting the neighborhood? where's the line that you're going to protect that, does it protect the residential neighborhood? 30 of those?
Well, that's the question. It's an accessory use clause is what we're talking about.
Right.
That's the line. Where do you put that line? I mean, to me, the accessory use is what's doing that. It's where you put that line that manages the tenor and quality of the neighborhood, or affects it in any case. I don't know how well it manages.
90, they'd have 45. It's almost every, you have 52, so you have 7 weekends that there won't be some random person.
90 days?
If it's 90, that's 45 weekends. So you have 7
Yeah.
that are, 7 weekends.
And I think 2 days is a really good sort of rubric for this.
Sure.
Thanks.
I'm wondering if a stronger protection for the residential quality of the neighborhoods would be perhaps a cap plus accessory use, but at a much higher limit than 30 days.
A much higher limit? Now, we just said 90 days is already full-time as far as VRDs go. How much higher do you want?
Well, it's a higher limits have been suggested in the city in the past, but
I know.
more than 30. But if you had both of those, you'd have both those tools at work. You'd have the cap, and you would have the accessory use. And the cap might be changed every time the city reviews its comprehensive plan or looked at again. And then the accessory use could be revisited by the city council to determine,
So
whether
we're back
that
to the
should be
cap by
changed.
zone concept. A cap in every zone that allows VRD.
By zone, yeah.
Cap's flexible. I think once we set what we call accessory use, I think we're going to get stuck with that one for a little bit longer than that. I think it's going to become a term that gets used all over the place.
Speak into the microphone.
I think accessory use is going to get stuck to us really hard once we establish that one, because it'll be a bellwether for everybody that's selling property and everything else. It won't be flexible. The cap can be manipulated, but I think the accessory use, when we stick on that number, whatever it is,
Why do you think that?
because of what you're just saying, is it going to be 45 weekends, or is it going to be 15 weekends, or is it going to be 7 weeks in the summer?
So you're saying a 90-day limit would be a really hard sell?
I'm saying whatever we decide on for that terminology, accessory use, it's going to hang around the neck for a long time. It's not going to be that flexible. Once it's established in records and what that means, that's everybody else in town, accessory use.
What do you think about accessory use, though, as a tool for implementing that sort of residential character of the comprehensive plan?
Well, what you just suggested, there you go. 30 days is 15 weekends. 90 days is the whole year. I don't know that really controls anything in a residential neighborhood. I don't think that does at all. I think the cap has the ability to control that, but I don't think the accessory use does. I don't really do.
Who are we trying to protect?
I don't know who we're trying to protect.
What
because
is the law state
there's
that
a-
we're supposed to do? Is protect
Well, there's
the
more
residential
than one.
neighborhood.
There's more than one of those laws. You also-
If
You are.
running a business isn't easy, it's not like a guarantee. It's a business.
Sure.
Running a business is hard. What's the success rate of business? How is it on the
They
resident?
fail more often than they don't.
There you go.
What I'm getting at is, I'm saying, though, that this is I'm not plus or minus on the accessory use. I'm just saying that one's going to stick with us.
And I think it's
So whatever we
mitigating it very
decide,
well.
we have to figure that, we got to get our brains together on what that is. I think the cap has more control over gentrification of a neighborhood than accessory use does. I think the cap.
Those are kind of mixed metaphors, I think.
But the cap allows for unlimited use.
Yeah, okay, but the cap allows for unlimited use on only so many houses.
Right.
And the non-transferable of the license that's not our issue, that ends that.
So-
every time it's sold. You have a way of saving a neighborhood a whole lot more with a cap than you do with accessory use. accessory use doesn't save a neighborhood.
So you have
But a cap can.
232 houses times 365 days a year, that many people, versus the current 162 people at 180 days. Those are the numbers that you're actually going to have.
I'm talking about a neighborhood is, I live there, and I know 6 of my 7 neighbors. Okay, that's a neighborhood. I live there, and I don't know any of them because they're all being rented out on the weekends. That's not a neighborhood. That's an apartment complex gone wild every weekend. I don't know. I like a neighborhood where I learn who my neighbors are, and I know 6 of them.
The definition of a neighborhood, right, not.
Me, it is, you know.
Well, that's the value that's expressed in the residential zoning, yeah.
So that's
And that's what a cap will do versus the accessory uses. It is an issue that we have to deal with, and it's a balancing issue. But the cap is the one that's going to make a neighborhood state a neighborhood. Because people will rent that house, or they'll use that themselves. I mean, we can't help the fact that so many of them are second houses, and people come here for weekends every once in a while. But keeping neighbors who know neighbors, that's a neighborhood. You don't know who your neighbor is because every weekend it's rented out to somebody else.
That's a hotel.
Yeah, it's apartment, whatever.
I feel that if you have 232 houses renting 365 days a year, that's a lot more random people than whatever the current number is. I don't know. I wrote it down. Sorry. But that, with 180 days at their maximum, and some of them are 300, it's more randomness. It's more. I don't feel that it brings it down to a neighborhood status.
Okay. What I was saying is, to me, the cap makes a difference in keeping the neighborhood under control versus the accessory use is not really that.
Well, those are different concepts. So the cap as proposed here doesn't apply to that neighborhood.
Well, sure it does.
Sure it does.
It applies to every single neighborhood, because
It's a residential neighborhood.
if you get to a certain percentage of people that have now got their VRD licenses, okay, now they can't get their VRD license. And if the accessory use is in control to make that, to me, I guess accessory use is the big key here, because if accessory use is used out of control, everybody's doing it, and there is no neighborhood. If it's controlled somehow, and I'm not sure how that is, then you have people that live there, and they're your neighbors.
Gary, let me ask you, are you quibbling with the notion of even having an accessory use in a resident?
I guess that's what that's what's running through my head. That's what's running through my head. Because I'm trying to figure out how to make a neighborhood, because what we have an obligation to do is make a neighborhood. And neighborhoods are places where people know each other, and they help each other, and they're part of each other's lives to some extent. I mean, it's not...
Oh, wait a minute, that's an unfair characterization.
Okay.
I'm not going to introduce evidence, but I'm going to make an anecdote, which is a person, me. I live in a neighborhood where there's a bunch of VRDs, and I know most of the owners.
Owners?
Owners.
Okay, so
of
you
the
don't know
VRDs.
anybody that actually is there ever.
And I know almost all of the people who come into the neighborhood. I've met them many times. They come back again and again and again. So the VRD isn't necessarily a non-neighborly kind of an experience. The owners of the place brought me a couple of crabs the other night, so very cool. But the folks that come into the neighborhood, they are also families. They have kids. The one 2 doors down from us now has 7 kids. They're loud kids, and they're having a lot of fun, and they go down to the beach and have a great. What I'm trying to get at is they come back often enough that I know them and they know me. They know Jane and I. So that I think we tend to get off a little bit on treating the people who come into to our neighborhood as VRD renters as some sort of aliens. They aren't really. They're pretty good people on the Main.
Well, I think one of the,
I'm not sure, I didn't address exactly what you were talking about, I know, but I just wanted to throw in that little additional perspective.
well, I think that's an important one, because community neighborhoods are important to tourist towns. It's one of the draws. So I think the challenge is, how do we make Lincoln City welcoming to tourists who rent VRDs, while at the same time making sure that we maintain the quality of those neighborhoods, because that is a tourist attraction. And those neighborhoods, we also need to make them desirable to retirees who might want to purchase a home there and live there. So we're thinking also of caps versus accessory use, and I'm wondering, going back to Deanna's point, one we made earlier, can't we use a cap and accessory use? So for example, you know, a zone, an R5 zone would have a cap of 12%, and those people who have VRD permits could rent them out, not 365 days of the year, but 180 or 90 or 120, whatever we think would be an appropriate fit for accessory use. So you would use both those management tools to make sure you're working hard to preserve, making sure the ordinance is in sync with the comprehensive plan.
Commissioner?
Sir.
Can I just give you a little bit of reasoning behind how we got here that may or may not help, but let me give you a little reasoning for the 30 days and a little more reasoning for the cap. As we approach this, the one thing we did not want to do was to completely eliminate the accessory use provision. There are some legal reasons for that, but we did want to take it back with a low enough number that it met the original intent of accessory use for vacation rental dwellings, and that is that the primary purpose of the home is to be a second home, not as a business. But you could rent your home as a vacation rental to cover some of the costs associated with having a second home. So the number is meant to be, now 30 days isn't a magic number, but it's meant to be low enough that it would meet that primary purpose, that the reason why the people own the home is because it's a second home. But if they want to try to offset the expenses, they would have the ability to rent it. You wouldn't get enough days that you could effectively run a business, turn your home into a business. That affects the nature of the neighborhood. Now, the difficulty that we faced with the accessory use, and the reason why we went to 365 days with a cap, is because we also did not want to punish or cause harm to our existing VRD owners. So you pick any number you want, and there's going to be a VRD owner that's going to be punished for it. If you put it at 90 days, you're going to have a lot of people that have based their decisions on our past practices. We helped to create this issue on our past practices that have invested a lot of money in the city that are now going to be run out of business, and because they cannot operate as they have been, as they invested for the property to become. One of the things that we noticed that is a changing in the VRD market is that these properties are now being purchased as investment properties, not as second homes. And we've had a lot of people who have made business decisions that way, mortgage decisions, housing decisions, and we did not want to put these people in a position where we are now somehow going to cause them great financial harm. That's why you have 365 days for the existing license and a cap so that you don't consistently have more than 365 days, or you don't even, or 180 days, or 190, whatever you pick, that it's a business investment. So part of it is to protect those people that have made significant investments in our community to operate VRDs without causing them financial harm. So that's why the 365 days is there. That's why the cap is also there.
Do we know how many VRDs actually rent more than 180 days a year?
We don't have that information, but...
But wouldn't it be through the TRT tax would reveal that?
No, because there's too many variables. For example, how much we receive in TRT can be dependent upon the number of nights they rent, and it can be dependent upon how much they rent that night for. We just simply get 9.5%. So I could get 2 weekends at $100 a night, or I can get 1 weekend at $200 a night, and I get the exact same amount. So there's too many variables in it for us to know without inventory and asking all of our VRD owners to provide that information. We have not done that.
But my sense is that very few of them would rent more than that.
Well, one of the challenges that we have is that when you listen to people and all of their comments and all that we have done is very anecdotal. And so what you hear is that the effect of us personally by VRDs, whether we don't own one but have one next to us, or whether we own one and I get it and I'm renting it for 20 days or 300 days. We do know what we've licensed them to do, and but not all of them are licensed for a specific number of days. And then if I remember my percentages right, only about 25% of them have a specific number of days on their license. So
I think what we're trying to do is fix all that.
I have rented them a lot, and you go out on their calendars, and some of the more cherry VRDs, and you can go through, they're full all the way across every month.
Could I call for a break? Could we have a bio break briefly?
Bio break?
You guys okay with that?
Yeah.
We're going to take a 5-minute break.
Yeah, thank you for your input. That
soon as you turn that microphone on.
Now we go public. Got a great idea.
Oh, yeah, right.
Lights are on.
Alice Batch.
Should we wait for Richard? Richard.
There's some creamer too.
Oh, hey, got two of the food sweets.
Didn't bring any candy.
Oh, sorry, the food pyramid's gone. It's a food plate.
Hey, didn't somebody used to bring candies and have their... Peas. Yeah, that'd be good right now. What's the show?
It's about the big rowing team from Seattle that won the gold at the 1936 Olympics.
Oh, wow.
Yeah.
No. I didn't know if they were official or not.
All right. Gary, you're up.
Well, unless somebody can come up with a golden spike, I feel like the numbers are what they come up with as best they can, and you know, we pass this on to the city council. They can decide if they like the numbers as they stand. Because we can debate whether 30 or 60 or 90. I liked what he told us about why they came up to where they came to, and I truly believe that, you know, gentrification of the neighborhoods is more a base of the cap number, but any particular neighborhood can take a brunt of the 12% and still end up in a mess. I don't know how you can alleviate that possibility without zoning the town into tiny little cubes.
And over control, or
Over
micromanaging it, I think
right,
was
and
the
over controlling it. I think
term we heard.
Typically, regulation, the more regulation that we impose, the higher the cost of doing business is, and the lower likelihood of having affordable housing becomes in any case.
So the lower likelihood, or the no likelihood?
Okay, whatever you want to go. I
It's
mean,
not there.
yeah.
Wait a minute, I missed the connection.
Well, what I'm trying
Go
to say
back
is,
and tell me what results in a lower likelihood of affordable housing?
more regulation. The more you regulate something, the more cost you impose in that something, and thereby the costlier it becomes. And that's just the economics 101 class. But on the other side of it, we have the obligation to keep neighborhoods neighborhoods. I think that they've worked hard at trying to come up with the 12% and limitation to 30 days, and I don't know that I can come up with a better number. So I would say that to move this forward, if that's the argument point, you know, we move it forward to the city council and let the wiser people make that
Well,
wonderful.
do you have a recommendation for them on the numbers?
I would stay with the numbers.
Keep them
that-
flexible, or put a...
I would say that at some point in time, we should have a review as a reaction to the market, you know? I think that somehow, this town needs the tourism, but it needs neighborhoods. You know, that's a balancing act.
Well, the review might, I mean, Mr. Chandler suggested that the best time for the review would be in comprehensive plan.
And that's coming how long from now?
This year, right?
The buildable lands inventory and housing needs analysis probably be done by the end of the year.
So the renewal be early next year or something like that? We would be looking at the comprehensive plan then?
Probably later than that, but probably in the spring.
That's probably a good time frame to see how things, market forces have reacted. I don't know how we're going to come up with a perfect number. I think they've tried their best to come up with a good number for us to start with. So maybe we debate the smaller minutia, and because we can fight this one and not get wiser.
Well, the first thing is taking away accessory use. You can't go anywhere else without addressing that.
Taking it away.
Right.
I think
We can talk about numbers and sections and zones, but first you have to accept, are you going to take away the accessory use and put in a cap? Once you determine that, then you can go from there.
Wait a minute.
We have
Taking away
both.
accessory use, aren't we just basically declaring that this is a commercial permitted use?
You're
VRD is
removing
a-
accessory use from the law,
From R5 zone,
from R1.5.
to a degree.
Commercial zone.
But they're still allowed, if a cap is reached and somebody wants to have a BRD, they can have one for 30 days.
Accessory use is still in the R15
Right.
after the cap is reached.
Right.
So
After the cap, which we would have been increasing it by 70 units already.
If we reach the cap.
If we reach the cap already establishes 70-something more units than what's already established, and also letting all the current houses be unlimited. Is that what you want to do?
It's a commercial zone.
It's a residential
Residential
zone.
zone.
Oh, I'm sorry.
R15.
And so that immediately takes away all the ones that are 30/90 already. What are we going to do? Or do you want to make it so that people can live there? Or do you want to make it so that people can visit? What?
I think we need to do both, because making it a good neighborhood is appealing to the tourists that come to our town. And I think we need to be very careful that we don't overburden a particular residential zone with VRDs any more than it already is.
And that's what we would do.
Which we, exactly, and that's going to be, huh?
Because we were increasing the number of units and letting them rent unlimitedly.
Right. So you had a lot more people, a lot more cars coming into these
Already.
residential
So
neighborhoods.
already
See how we're actually increasing the number of units.
The 12% is an increase.
Right now, there isn't any limit.
If we make a 12% cap, it would increase the number.
We're putting a limit. We're not increasing the number, we're just putting.
We're putting a limit, and that would lead to an increase of 70 more
Something that
VRDs.
currently doesn't have a limit. So I don't see how that makes it more unlimited.
I really have a hard time believing that for any length of time that those 70 possible units would not remain, they would, would go to VRD.
You think that's going to fill up pretty quick?
I believe that creating the cap would absolutely, they would take that and go.
They would
There's
take
already
that and go.
to make VRDs.
I think what Riley is saying, if the cap is put in place, there's still room for the development of more VRDs in R5 zones, and developers will use that as an opportunity to build 70 more VRDs in an R5 zone.
Not even build.
Or just convert, which means that a lot of the homes, perhaps in Cutler City, the older sections of Cutler City or Nelscott, will lose monthly rentals that are affordable currently.
Long-term rentals. We're talking
Yeah.
long-term rentals versus short-term.
Do you think that the market doesn't have anything to say about that? I mean, look at where the housing hasn't gone and the licenses haven't gone. I think that that's more problematic because of the fact that I think we've got them scared. There's a great amount of uncertainty when a community is really playing with.
Who is scared?
The people that would spend the money to buy the VRD.
So we're
or build them.
scaring away
But
potential
No,
businesses?
what I'm trying to get at, though, is these people are out of the market right now, and we're under that number, and the number isn't going like that, and it wasn't going like that, and if it was going like that, we've got a cap that shuts it off at 70 more units. I just, I don't know, I don't want to see neighborhoods getting creamed.
And that's what would happen.
Well, 70 units doesn't cream a neighborhood.
70 unlimited units. 70 more unlimited. 232 unlimited units.
Well, I guess
How is that not more burden?
I'm losing the ground on when you're saying unlimited, because to me, if you're renting it for 180 days or you're renting it for 365, there's absolutely no difference.
And why is that good for the neighborhood? Because that's good to protect the neighborhood like that? It's as if that doesn't matter. It's okay that
I'm not
happens.
saying it's, you know, a neighbor has a problem with it in a VRD, but I'm saying you have to have some kind of a balance where
People
you
who don't have a place to
lot-
live have a problem with it.
What now?
People who don't have a place to live have a problem with it. People sleeping on couches have a problem with it. People who don't have a house to live in have a problem with
Okay,
it.
they're not going to buy a VRD.
They're not gonna
nor
buy
are
a
they
VRD.
going to rent a
They
VRD,
could
nor
rent a
are they going to
long-term home.
occupy a VRD.
But it doesn't matter. It
It's a
doesn't have to be
different place.
oceanfront to be a VRD.
Well, I know, but we are making a regulation that would actually limit them to some extent on the rest of the community. You're actually doing something that will actually put the rest of the community as a more rentable area. I guess if you don't have a job, you don't live eventually. You run out of economic circumstances if you don't have a job. And if we chase jobs out of the community, if we really do, and people will go somewhere else. I mean, I've rented places besides Lincoln City, and I'm just saying that at some level, you've got to be careful that you don't shut down the economic engine that is employment, because you're trying to build neighborhoods that won't have anybody that can afford to live in
But
them.
you're assuming that people don't have a job. These are people that have jobs. These are people that would rent if there was houses. There aren't houses to rent, so we're
I
creating
realize that, but you're
more
not
houses
gonna make
that
them out of
would take away.
VRDs.
We're taking away for those long-term rentals.
The gentrification would take it
How do we
away.
do that?
How?
How are we taking away long-term rentals?
If you make more houses available to be VRDs, and you allow them to
Oh,
rent
I see, you're talking about
more.
long-term rentals.
Long-term rentals, yearly people who want to work here and live here. All I see is that you're removing even more the stress that it is.
So the fundamental problem I'm seeing here is the statement that if you impose caps, you're going to have more VRDs than if you don't impose caps.
There already is a problem with the number of VRDs. And
No,
we're
no,
just making
that's
that
just
more.
this question. If you put a limit,
A 12%
that limit
cap,
is going to
yes.
cause there to be more VRDs than
Yes.
if you don't put a limit?
The cap that they have
It's just like a
suggested
speed
puts more.
limit, speed limit. If it's unlimited, people will go 50. If you make it 90, people will go 180.
The licensing.
Well, I think you're raising a good point, and I think if, how to articulate this, if we had not, if we didn't have a cap, but we had accessory use, and anybody who wanted to could apply for a VRD permit, because there's no cap, you know, but if they're only allowed to rent for 30 or 60 or 90 days a year, is that going to mean, you know, how do you balance that against, you know, having a cap and having a VRD being rented 365 days a year in terms of the number of people that come into the community, the number of cars that come into the community, the impact on existing housing. And I think we got to find a balance that sort of maintains the character of these residential communities and is welcoming to VRDs and to retirees and to full-time residents here. And I'm not sure that, you know,
You think doing nothing is going to achieve the
I don't know.
goal?
I think there may be another solution out there than this, like a cap.
I don't know,
and
I kind of like this solution. I mean, after 4 years of fighting this thing and hearing all of the other solutions, the most solution I hear is, let's not do anything. Let's just keep doing it the way we've been doing it for the last, 21 years. Let's not do anything. Now we have, I think Gary has pointed out this, we have very talented people working on this. city manager has done a phenomenal job. And a lot of the speculation of what's going to happen if we impose these caps, I don't have a clue that, I don't have a reason to believe that if you impose a cap, there's going to be more VRDs than if you didn't impose a cap. And I don't have a vision that says if I impose a 30-day limit that that's going to be worse for the neighborhood than if I don't impose any limit. I don't understand that. To me, those seem like reverse consequences. I like the approach of these two items, the cap and the limit. But obviously, it's very controversial in this group.
I think it's good if nothing else that the comments that we got in here were totally opposed to the caps and the limits.
Who were they written by?
I'm just saying.
Oh, yeah.
The point is there was a lot of people who have invested money in this town who feel like this is going to hurt them. Okay, whether it's true or not, I'm just trying to say that we have people on both sides of this issue, which generally means you're aiming in the right direction because you've got people that are mad at you from both sides. And that's usually a good place. It's a good common ground to be at. I want, and you can tell from what I've said in the past, I want affordable housing in this town. I see affordable housing in this town as being the most crucial fight we should be fighting when we can. This is a side note, but I'm just saying, I want to see affordable housing, but I don't want to see affordable housing that's affordable for doctors. I want to see affordable housing that's affordable for the people that work
Rent a
here.
3-bedroom house for $1,900.
Well, that's what I'm trying to
That's
say.
what
Or
it is.
$1,700. I realize that. And you know, you get a one-bedroom apartment, starts at $780 and goes up from there, that it doesn't have bugs in it. And so, you know, I realize that it's not affordable. Okay? It's not affordable in this town. But I don't think that VRDs are going to cause it to be affordable or not. But I do want to have jobs.
You make more money with a VRD than you do a long-term rental.
I realize that, but if we have a cap, we're going to shut that lid. We're going to put a lid on, at least at some level. We're going to put a lid on how many places convert to VRD.
And the amount of TRT tax that the city receives isn't enough. We need to make more. We need to increase that more. It needs to be more. If we allow for more.
I'm not sure what that has to do with one or the other. If you don't put a cap on it, then the idea that you could end up with 25 or 30% VRDs is true. Okay, you put a cap on it, you won't get to that number. Okay, if you don't put a cap on a VRD number, you could get to 50% or 100% VRDs in some vague way. But if you put a cap on it, you won't get to that number.
Because there won't be a cap.
Well, I guess I'm wondering why this argument is an argument at all, because if you don't put a cap on it, you could get to
50%.
whatever number. But if you put a cap on it, you've put a cap on it.
Is the question whether to have a cap or what percentage the cap should be in different zones?
Or altogether.
Good question, Deborah. Gary, can you answer Deborah's question? Answer Deborah's question.
I don't know, because to me, I can see that a cap at some level will in fact stop a total collapse of a neighborhood, ERDs. So why are you arguing against the cap? I would ask that question.
So you're saying you said you agree with the number that's provided here, the 12%?
I think that you guys have made a good starting point, and I think at some point in time, we have to revisit that, if we have to revisit that. But I don't know that I have some magical number that's better than that number, but I think that if you don't say cap, then you do have the possibility of a 40 or 50% of the R15 going into VRDs.
We don't have a cap right now, and if we took all the houses and all the VRDs, what's that percentage, did you say? All the houses in the whole city, and all the VRDs, what's that number?
Oh, it's 8 or something, isn't it?
8%?
You know the
VRDs to homes.
for the whole
It's about,
city?
it's about 8.35%.
But that's for the, no, it's 8.35 for the R15
For
zone.
the entire city.
I don't,
It works out the same for the entire city, too.
does that include roads end?
But, well, actually, the 8.35 in the R1 zone is the number of VRDs to the number of lots. It's the same proportion for the number of VRDs citywide as there are dwelling units citywide. This coincidence is the same number, but I just ran the number, that's why I know that, so.
But theoretically, a 12% cap could lead to 40% more VRDs in the R15 zone. So why don't we consider a smaller cap? So we would reach that cap sooner, and that would be it. You know, better chance of preserving the current residential quality of those neighborhoods. Say,
Do you have a number?
Yeah, make a motion.
well, change the cap to 10%.
Let's put that on the table. What do you think, Riley?
I don't believe we should put a cap.
What do you, Gary, what do you think?
Microphone.
I'd say that if we, if we're worried about the town going into VRD land, we need a cap, just to keep it from happening. I'm not
Well,
sure that I agree.
We definitely have one neighborhood up in the north end that shows that it can happen.
It already is, it's not going to.
We're at, what percentage of roads end is VRDs?
18?
18%.
So, that's where we can be going, could be going,
Without a cap.
without a cap.
So I would agree with a cap.
I think a smaller cap would be good. On the other hand, there are other aspects of having a cap I just don't like. The R7 zones don't have a cap. They're governed differently, and I don't know.
The cap allows.
The cap and accessory use are inextricably intertwined, don't you think? Eliminating accessory use and putting the cap.
It's allowing it to be a full-time business versus accessory use.
But it actually, the cap puts a 10% or 10 or 12% limit on VRDs that are operated 365 days a year, but there could still be VRDs in R5 neighborhoods that are operating
Yeah, cap
30 days a
doesn't
year.
affect-
So it's still, you're not really limiting the number of VRDs, you're limiting how they can function.
Yeah,
You're limiting them as a commercial use.
and that was the distinction Commissioner Hinton was making last time we met. We really need to think of these, and she posed this thinking of them as different things. This is a commercial venture, and this is an accessory use. This is a residence.
They're investments, he said.
These are commercial uses.
I think by the 30-day cap, or the 30-day use would make it more economically viable to put that house into the month-by-month rental basis if they wanted to garner more income from it than they can by the 30 days of VRD rental.
Well, the demographic that we heard was that these are typically second homes that people rent out a few nights a year in order to defer the expenses of having a second home.
Yeah.
I mean, that's the sort of the classic definition of a residential VRD.
Is there a time frame on our deliberations? Might make sense to...
To midnight, I think.
To continue this discussion to our next meeting?
It's till 10 o'clock.
10 o'clock.
Or are we compelled to make a yea or nay tonight?
But we're still on section 1.
The code, I believe, 1788, says that you have 60 days sorry, the code says in 1788, you have 60 days from when the item is referred to you to make a recommendation to the city council. If you don't, it goes on to the city council with a positive recommendation. However, there's some language in there that says, unless additional time is provided, and that's with the agreement of all parties. It's not really clear how that works when it's a city-initiated amendment. So I don't know where you are in terms of, I mean, we just concluded the hearing, so.
Nowhere in here did I see any kind of accountability for negative stuff or, you know, what happens if something, that's a licensing thing?
In all land use matters, you have the ability to enforce land use restrictions through an enforcement action, which has a prerequisite notice of violation, or through revocation. So those things are addressed already in the code. And I don't think there's any proposal to change that. I mean, you're adding, this would add limitations to the code, and those limitations would be enforced through existing mechanisms. I don't think there's a ban or a prohibition about you continuing this to deliberate at the next meeting. It just depends on how late you want to stay, and I think you're correct that it's a 10 o'clock cutoff under Planning Commission rules, so.
8 o'clock. If the other commissioners are back, they can participate if we defer this to the next meeting, as long as they've read
If they,
to the tape.
if they listen, yeah.
Tape. I know. Well, gentlemen, we have the option of deferring this or doing something about it.
I would like to try to pass a motion to go forward with it, but I don't think we're going to get the support, so I'm not sure I want to
Make
do
the
that.
motion and see what
We'll make the
happens.
motion. I motion that we move this as it states forward to the city council with our recommendation to approve.
Any amendments to it, any,
No? Just like I said it.
do we have a second? I'll second. Could we have a roll call, please?
Cunningham,
Yes.
Griffiths,
No.
Oakland,
No.
and Robinson.
Yes.
Okay, the motion fails.
Make a motion to defer this into our next meeting, 2 weeks from today.
Second.
Would you call the roll, please?
Right, so that would be Tuesday, August 16th at 6 p.m.
Yes, that date.
Griffiths,
Yes.
Cunningham,
No?
Hoagland, Robinson.
Yes.
Motion carries.
All right, we have deferred ZOA 2016-05 to our next scheduled meeting, which is the 16th at 6 p.m. Old business,
We have none?
new business, reports and comments, Community Development Director.
two things I'll mention to you. At your seat tonight, there was a fairly thick document about the Oregon Coast Economic Summit this next week in Coos Bay. You'd asked about more information about that. That's among other things that are being discussed. There's a panel on affordable or workforce housing that I'm participating in. It's actually, I just looking over that the other day when I got it. It's quite a big deal conference. We've got Senator Wyden, member of Congress are going to be there, the Attorney General, the Secretary of State, and a number of members of the Oregon Legislature presenting things. It's a two-day conference on next Monday and Tuesday in Coos Bay at the Miller Casino. The other thing I want to mention is I passed out to you tonight a little flyer about tomorrow from 10 a.m. to noon at the Oregon Coast Community College here in Lincoln City. There's a workforce housing panel discussion, which it says, hear from experts about options for and experiences with developing housing that is affordable to working families in Lincoln City, Depot Bay, Siletz, and surrounding areas. So,
When was that again, please?
tomorrow morning between 9 and noon, or between 10 and noon.
10 and noon.
If we plan on attending, we can,
Pardon me?
if we plan on attending, is there any kind of,
Not that I know of, but
Fine
I'd be
with
happy
that.
to have people come.
okay.
This one, do you know what the cost of that is?
I believe it's free. You have to register, and you can register online.
With the summit? Summit he was asking?
Yeah, the summit.
Okay.
City Attorney.
I don't have anything.
Planning Commissioners, any reports and comments? No public comments on non-agenda items not involving a public hearing. None. Future agenda items and next meeting. The next meeting is August 16th. We'll be looking at the VAR 2016-01 Lovelace request for a variance and continuing the discussion of ZOA 2016-05 VRDs. We're adjourned.